I'm told that there is a listing on the 23rd of February for judgment, though we're not entirely clear what the judgment would be. But those are the essential facts that I rely on. But there is one very important point that I want to bring to your Honour's attention at the outset, and it's the respondent's reply in the Dubai proceedings of the 27th of January. And your Honour will find it in a bundle which I hope you have, which you probably haven't looked at, the Supplementary Hearing Bundle A, which has 9 tabs.
Bundle A? Actually, I have as a number 1, 2, 3 as a volume.
Yes, this is file 1 of 1, and the spine should say Supplementary Hearing Bundle A.
Which is witness statement?
No, not statements. It's we can have another copy.
Okay.
Has nine tabs.
Is this what's called the core bundle?
No, it's Supplementary Hearing Bundle A it is.
So it looks like that. That's it. That's nice.
No, I don't receive this type of note.
And then that's what it says on it. That's it. These are the.
Which is this morning you filed?
So I think it was filed.
This morning you filed this supplement.
No. Yes, Your Honour, it was this morning.
Yeah. Which tab?
If you could go to, well, the Arabic is in tab 3 of the bundle. And I'm afraid I will have to refer to tab 4 in the English. What I would ask Your Honour to do, if you wouldn't mind, is just read in the Arabic of tab 3, paragraph 1, the whole of paragraph 1, which is subdivided into 17 subsections.
Which is consistent with jurisdiction application before the Dubai court, right?
Yes, exactly. Before the Dubai court, dated the 27th of January.
Yeah. And your point here?
If you look at the key point is at 113. That's where it's stated in the most concise way. But the same point is made throughout this document. And if you go to 113, what you'll see is taking the above into account, the opponents are allowed to request nullification of the arbitration award when the court hears the ratification request. The DIFC Court of First Instance has ratified the arbitration award subject to the lawsuit, and the judgment has acquired the res judicata effect in respect of the DIFC Court's jurisdiction to ratify this judgment. Thus, the Dubai courts lack jurisdiction to hear the present lawsuit. Now, Your Honour would have seen that that position, that the judgment of the order of Justice Steele, dated the 15th of September, has acquired a res judicata effect, and that the Dubai courts therefore lack jurisdiction. Now that is extremely important in the context of this case, because Your Honour will appreciate that the order is simply an ex parte order. It cannot possibly have a res judicata effect. It was granted, quite rightly, on an ex parte basis, without my clients having any opportunity to make submissions as to whether it should be that should be granted or not, and whether or not, and what the effects of that order are. Now that, Your Honour, is very, very serious. And the reason it's very, very serious is because it is wrong, and it is obviously wrong, and it is misleading. And it is misleading to the Dubai court. Now, it's very important that the process of this court, which is in essence a common law court, which allows ex parte applications to be made, that they are protected. And the law gives very powerful protection in relation to parties that misrepresent the position. It's not just a misrepresentation to another party, but it's in fact a misrepresentation to the court. And I just want to show you one case which shows you how seriously that position is taken. If you go to our authorities bundle, tab 44A.
Authority bundle?
Yes, it should be in bundle authorities bundle 2.
I don't have 44.
Oh, don't you? If you don't, it should be in your additional documents.
Actually, I think I have.
Do you have
one
any-
of them.
Does your Honour have an additional document?
Okay, authority bundle number?
2.
Number 2.
Yes. 44A. I hope someone's put it in your Honour's bundle. Maybe it's over optimistic.
Yes, 44.
A.
The cases?
Euroil Limited and Cameroon Offshore Petroleum.
No, this is the case. British Overseas Airways.
Here we are. We'll hand it up. Now, just to explain to Your Honour what this case is about, as Your Honour appreciates, it's a decision of the English Commercial Court. And Your Honour will appreciate that in many situations, an injunction is applied for ex parte. So an injunction is applied for on the basis that there is an arguable case and that another party needs to be restrained from doing something by an order of the court. And at the ex parte stage, there is an obligation to make full and frank disclosure to the court, and the court, if persuaded, will then make the order. And what happened in this case was an ex parte order was made and granted by the court. And if you go to paragraph 7, you'll see what the judge says is, after the making of my order, the meetings in Cameroon took place. What happened was that the order I made was served on Camot. That's the defendant respondent. Camot considered that the terms of the order put it in a very difficult, or indeed impossible, position in participating in the meeting, and it decided to prepare an opening statement which would be read out verbatim during the meeting and to take no further part in it. That decision was made between Camot and its solicitors, including Mr. Michael Wachtel, a partner in Clyde & Co, who was participating and had always been intended to participate in the meeting. The statement was read out at the beginning of the meeting as follows. We thank you for inviting us to attend these tripartite meetings. We have attended today in good faith with the sole purpose of working together with all parties to further the interests of us all and enhance the development of the Attinde permit. However, as a result of litigation commenced by Euroil yesterday at the High Court in London, the papers for which were served on us only 90 minutes before the hearing commenced, we regret that we are unable to participate in this meeting other than to observe. We are providing you with a sealed order of the court with which we must comply and which we will vigorously contest next week when the case is back before the judge. We are unable to comment further at this stage other than to state again that our sole objective is to make this project a success for all parties involved. So in other words, as a result of the court's order, a meeting that was intended to take place for negotiation purposes essentially didn't take place because of the restraining order. Mr. Cook, for the claimant, submits it's not correct to say that the order prevented Camot from participating in the meeting, but as I read this statement, it is not necessarily to be read as saying that the order prohibited Camot from doing so, rather that Camot had taken the view that in the light of the order, it could not safely go further than observing. And then he says that at 10 and 11, the reading of this statement had a considerable impact. Now the important point is paragraph 12. A further point, which I should mention, is that in the course of the meeting, after the statement had been made, Chief Tabitando, who is the executive chairman of Euroil, i.e. the party that obtained the injunction, stated that the fact the High Court issued the injunction was conclusive proof that cannot was in breach of the joint operating agreement. Now, Your Honour, you'll appreciate, to get an injunction, you simply have to show you've got a sufficiently arguable case. It doesn't determine anything one way or the other. In general, it simply holds the ring. So that statement, which was made in this context to a private party, was wrong and should never have been made, and that's what the judge says. That, of course, is a clear misrepresentation of the position. I decided no such thing, but made it clear, and make it clear again, that that question is for decision by the arbitral tribunal in due course. So in this case, it was it was an injunction in support of arbitral proceedings. So the court didn't even have jurisdiction to decide on the merits. That was for the tribunal. But to suggest that there was anything conclusive was wholly wrong. Now, I pause at this moment because absolutely that would be operative if you were making a statement to other private parties. But in my submission, it's even clearer when you are making a statement to another court of the position in relation to the judgment. That is an even stronger case. What the judge says at 13 is, in my judgment, it is completely unacceptable that the effect of the injunction should have been misrepresented to SNH in this way. I regard that, in effect, as an abuse of the court's process, which is itself sufficient to discharge this injunction, although there are other grounds on which I also propose to do so. So, Your Honour, the short point is a simple one, and that is this. The order of Justice Steele was an ex parte order, properly made ex parte. In order to protect the integrity of this court, it is not right that the effect of that judgment, as a res judicata, finally deciding the issues in that order, and saying to the Dubai court, not only does it finally decide it, but that means that you, the Dubai court, does not have jurisdiction, is in itself a ground for the discharge of the order.
But again, you can't raise this issue before the Dubai court in misrepresentation, correct?
It has been misrepresented to the Dubai court, exactly.
But of course you can't raise this issue before them in Dubai court. I mean, you have to raise this issue before the Dubai court.
Well, the point is, yes, of course we must do that. Of course we must raise that with the Dubai court. But that's not my point. My point is that to abuse the order in that way is an abuse of the process of this court. And that is why the order in my submission should be discharged on that ground alone. Because it is not right that the order should stand in the face of a misrepresentation of that kind. And what should happen is that the order should be discharged. The Dubai court should be told that before the 23rd of February, so that there is no misunderstanding whatsoever about the effect of that order, and that it cannot be contended that it is res judicata when it is simply an ex parte order. What happens after that is another matter.
Yes, Mr. Black.
My Lord, I'm sorry to interrupt. My Lord will have seen the skeleton argument filed on behalf of Meydan in this case. You will look in vain to find this argument anywhere. It has just arisen as my learned friend has spoken it. The papers upon which it was based were just handed to me this morning, saying they're just some additional papers. I was not told that there was any such argument as this going on. I am completely unprepared to deal with this argument. It's not been highlighted in any way. I have not had an opportunity to discuss with counsel before the Dubai court what was said there. I've not had the opportunity in any way to investigate this. This is the first time you see that this authority is one that isn't even in the original bundle. It was handed to me as I walked into court this morning. This is completely unacceptable.
Sorry, if my friend wants time, I agree with him, this is a very serious point. If he needs time to deal with it, he should have time. But it must be dealt with.
Okay, then we have two options. We can keep it for tomorrow as a last closing submission point, or supplementary submission after the hearing.
Well, as I say, I have to speak to Dubai counsel who've been before the Dubai court, so I don't know whether I will have the opportunity to speak to them tomorrow, so it may have to be dealt with by submission. So if we can hold it over until tomorrow morning, then I can tell the court whether I had the opportunity to take instructions upon it. But I should say it's a completely unacceptable way to proceed, generally, particularly since it's based upon a document that was filed in the Dubai courts more than 10 days ago. It could easily have been put before this court last week. I could have been in a position to deal with it. It is, I'm afraid, not atypical of the way in which much of this litigation has been handled, and I will in due course be inviting this court to take a very dim view of it.
Thank you. Then let's hold this point until tomorrow.
Yes.
At least Mr. Black will have an opportunity to look at it and reply by tomorrow.
Yes,
We can move to the second argument.
Yes, of course. Can I just say that when my friend complains about these documents, the documents are court documents which they in fact requested to go in the bundles. I myself only saw them yesterday for the first time. They say they are absolutely plain what they say. So I don't understand what's going to be said about what was represented to the Dubai court. But as I say, I'm happy to leave it over. That's a perfectly sensible course. But it is a very serious matter, and it does need to be dealt with. And I have to say that although my friend says that it's how the litigation has been conducted, what's sauce for the goose is sauce for the gander. We would like to see their explanation as to how this position came to be misrepresented to the Dubai courts. But I will leave that over and hear what my learned friend has to say about that. So
we'll move to the second argument then.
yes. Can I say one other thing that I probably should raise at this stage as well, which is a housekeeping matter? I know that Your Honour hasn't had a chance to read a lot of the underlying documents, but one of the things we asked you to read was Dr. Berhad's report. But objection was taken to that report, and at the moment the status of it is not clear. At this stage I can simply say that so far as we're concerned, we think it's important evidence, and Your Honour should have due regard to it. And I'm happy to leave it at that stage and we deal with it in due course if Your Honour thinks that's appropriate.
Yes, we do object to the inclusion of that, as my learned friend rightly says, report, although it's called a witness statement. It is indeed an expert's report, which again was served 3 working days before this hearing. It is a very scholarly, learned document that must have taken many weeks, if not months, to prepare. We have been given no opportunity, realistically, to respond to it in any meaningful way. It is, of course, in breach of all of the court rules relating to the service of expert evidence, and consequently we will be submitting to you, if reliance is to be placed upon it, that it should be excluded.
Noted.
And can I just say in response to that, so that Your Honour knows what the ambit of the debate is? We say that the issues raised on this application are of fundamental importance, not just for the parties, but for this court, for Dubai and the UAE. And it's therefore important that the court has the evidence before it in order to make a fully informed decision. Now, it is not contended that the evidence should be excluded on the grounds of relevance, and that is quite right. And we do not accept for one moment that it is expert evidence, properly so called. One of the important elements of Dr. Berhad's evidence is that he can give first-hand factual evidence of what happened at the time. So we don't accept that it is expert evidence, and that is why it is in the form of a witness statement. But as Your Honour wants to deal with it later, we will leave it at that. But I do want to make it clear that so far as we are concerned, we are relying on that material. So then I turn to the jurisdiction point. Now that ultimately comes down to the construction of Article 42 of the DIFC arbitration law. Does it apply to awards from Dubai? Can it apply to domestic awards which are not DIFC awards? Now, for shorthand, I would call them domestic awards to distinguish them from DIFC awards on the one hand and foreign awards on the other. Now, our position, in short, is that firstly, the DIFC's jurisdiction to recognise and enforce arbitration awards comes from Article 5A(1)(e) of the Judicial Authority Law and Article 42 of the DIFC Arbitration Law. So the extent of the jurisdiction is therefore defined by the four corners of Article 42. Now, on its face, Article 42 applies to all arbitration awards. And on a literal interpretation, it is certainly an available meaning of the words. However, in appropriate circumstances, the court will depart from a literal interpretation. And I should say one has to be a little careful about terminology here. It is certainly an available meaning of the words, and possibly also the most immediate meaning, but it is certainly not the only possible construction of Article 42. And we say there are appropriate circumstances here, and I'll explain that submission in a little more detail. In particular, we say that the position before the arbitration law only permitted enforcement of domestic awards once they had been ratified. And if you interpret the arbitration law as changing that, all sorts of problems are created. Firstly, you have two different courts in the same state deciding the same or very similar issues in parallel. You have a mechanism for avoiding the defences which apply specifically to enforcement of domestic awards, not foreign awards. And thirdly, you end up with situations where the domestic courts, in this case the Dubai courts, face conflicting obligations under the law. Now, all of that is avoided by limiting the application of Article 42 to DIFC awards and foreign awards. And at the outset, I should make two things clear. None of what we are arguing has been argued before. The court has seen a number of attempts to resist enforcement of arbitration awards on the basis that there is no connection between the award or the parties and the DIFC. And that has been argued in multiple ways, as a jurisdiction argument, as an abuse of process argument, as a constitutionality complaint, as a public policy defence, as a basis for refusing enforcement as a matter of discretion. And all of those arguments have failed, and we don't adopt any of them. Our position is based on the nature of the award, not on the question of whether or not there is some nexus or connection with the jurisdiction. Secondly, nothing we say affects the recognition and enforcement of DIFC awards or of foreign awards, that is, awards from outside the UAE. Those awards are subject to the DIFC enforcement regime, and the model law approach to enforcement is applied. So what we are arguing are new points, and we say they don't upset in any way the orthodox approach. The Banyan Tree case did concern a domestic award. However, in that case, and it featured significantly in the Court of Appeals judgment, there was no annulment application on foot. In that case, there was a debate about whether an annulment application could be made absent an application to ratify and enforce. And that mystery has been solved. You can. And that is what the defendant has done. And that, we say, brings into sharp relief the problems which follow if you allow domestic awards to be enforced in this way. Now, I should say, I think it's pretty clear from our skeleton argument that should we go to appeal, we will challenge the decision in Banyan Tree, but we're not doing that in this case. We are saying we accept the decision, but we're distinguishing it. And as I say, we accept that in one sense, Article 42 does appear to cover domestic awards. And can I ask you to go to Authorities Bundle 1, tab 11, page 18.
Which tab?
Tab 11.
Yeah, affiliation law.
Yes, and go to take me to 42.1.
Yeah.
And if you look at 42.1, it says, an arbitral award, irrespective of the state or jurisdiction in which it was made, shall be recognised as binding within the DIFC. So if you take that purely literally, that would include domestic awards. And that is one of the reasons that my learned friend says it's hopeless to argue that domestic awards are excluded. And the implication of that is that the court must always follow the literal wording of a statute. But we say that is wrong. The law has never followed slavishly the literal meaning of legislation. Both statutory and contractual interpretation have developed. And you can see that in particular from Bennion, which is the leading text on statutory interpretation. I'm afraid you'll have to go to the second authority bundle, that's tab 47 for that.
Tab 40.
Tab 47.
I have a problem with that.
Yeah. And you see, if you look at the bottom of the page, 429, strained construction, section 157. Where on the facts of the instant case and taken by itself an enactment has a clear grammatical meaning, do you see that? It is a strained construction to give it a different meaning. 2. Where an enactment has two or more grammatical meanings, or in other words is ambiguous, it is a strained construction to give it a meaning other than one of grammatical meanings. Where an enactment is semantically obscure, it is a strained construction to give it a meaning other than the grammatical meaning, or in the case of ambiguity, one of the grammatical meanings of the corrected versions. And if you go over the page at section 158, it says when strained construction needed. Do you see that?
Yeah.
There are broadly 4 reasons which may justify, and in some cases positively require, the strained construction of an enactment. A repugnance between the words of the enactment and those of some other enactment, consequences of a literal construction so undesirable that Parliament cannot intend them, an error in the text which plainly falsifies Parliament's intention, or the passage of time since the enactment was originally drafted. And then if you go to the next page, page 431, this section states in very broad outline the main reasons why sometimes a strained construction of an enactment is necessary. In many actual cases, the reasons overlap. Each reason is related to the intention of Parliament. As Blackstone pointed out, it is not always enough for a lawyer to say, lex scripta est, thus the law is written. If you go on to the next page, page 4, at the top, for the court to apply the literal meaning regardless of consequences is contrary to the judicial oath requiring a judge to do right. Consequences of always applying the literal meaning can be so extreme that they could not conceivably have been intended. And then over the page, page 5, at the top of the page, there is a tendency in our systems, less evident in some recent decisions of the courts, but still perceptible, to overemphasise the literal meaning of a provision, i.e. the meaning of the light of its immediate and obvious context, at the expense of the meaning derived from other possible contexts. And then at the bottom of the page, the true rule, instead of attempting to rule out altogether departures from the literal meaning, what interpreters need to do is recognise that the literal meaning carries great weight, but may in rare cases be outweighed by other interpretive criteria. To this we can add a related proposition. The stronger the claim of a particular meaning to be the clear literal meaning, the weightier will the factors arising from opposing criteria need to be if it is to be displaced. Finally, it should be remembered that the literal meaning includes implications. So it is plain that in appropriate circumstances, a literal meaning can be overtaken by another meaning. Can I just give your Lordship, Your Honour, an example? And it's not an example of my own, it's actually an example that one finds in the cases. If you have a sign or a rule which says, no cars in the park, that is a very clear rule. No cars in the park. But the question is, first of all, what about police cars? Why should it include police cars? And in my submission, it's very easy to see that you could exclude police cars on the basis that it is not the type of car that is intended to be prevented in the park. The other example is a toy car. What about a toy car? A toy car is a car. So is that a car that falls in the rule, no cars in the park? And in one sense, a literal meaning would say, well, they must be excluded. But common sense would suggest that that can't be right. And the real question is, what is the nature of the car that is intended to be excluded? Now, you may say, you may have a lot of analysis. Why do you have a rule, no cars in the park? One reason is to protect public safety. So then you would say, well, if that is the mischief against which the rule is guarded, you would say, well, then on that basis, you would allow police cars. What about an ambulance? Are you to say that you can have an ambulance if it is not in the form of a car, but not an ambulance which is in the form of a car? It doesn't make sense. So even when one is debating the literal meaning of the words, the literal meaning of Article 42, the true question is, what is the nature of the award that is contemplated by Article 42? Just as the example I've given, Your Honour, of no cars in the park, what is the car that is contemplated by the rule? It doesn't simply mean every single possible thing that could fall within that definition. One has to do a sensitive analysis. And in this case, we say that if you don't do that, there are very serious consequences. So when you're interpreting Article 42, the task for Your Honour is fundamentally to discover what its meaning was. And we say there are many, many examples. My car example is just one of them, where the meaning is different from the literal words of the statute. And we say in this case, what is very clear is that if you give it a literal interpretation, as my learned friend says you should, it would produce a conflict of legislation, and it would produce a result which is so undesirable that we say that cannot have been the legislator's intention. So we do say that this is not hopeless. You're perfectly entitled to depart from the literal interpretation, and you have to look at the consequences. And we say there are 5 problems which fall into one or other of these categories if Article 42 does not include domestic awards. And there are other good reasons for construing it in a way which excludes them. First one is conflicting obligations in relation to the domestic courts. If you include domestic awards in Article 42, you inevitably end up with a situation in which the domestic courts are both obliged to enforce and obliged not to enforce. The obligation to enforce arises because once you recognise and enforce an award in the DIFC courts, you can insist on it being executed in the Dubai courts. And if you go to the authorities bundle, tab 9, tab 9, you'll find the judicial authorities law. Article 7.2, page 5. Where the subject matter of execution is situated outside the DIFC, the judgments, decisions and orders rendered by the courts and the arbitral awards ratified by the courts shall be executed by the competent entity having jurisdiction outside the DIFC in accordance with the procedure and rules adopted by such entities in this regard, as well as with any agreements or memorandum of understanding between the courts and those entities. And then it sets out the conditions, and then in 7.3 it says In addition to paragraphs A, B and C of clause 2 of this article, when executing the judgments, decisions and orders issued by the courts or arbitral awards ratified by the courts through the Dubai courts, the following must be observed. Subparagraph C, the execution judge of Dubai courts shall apply the execution procedure and rules stipulated in the aforementioned Federal Civil Procedure Code, including any objections to the execution. The execution judge may not reconsider the merits of the judgment, decision or order. So arbitration awards which are ratified by this court must be executed by the Dubai courts. So the result of including domestic awards in Article 42 of the arbitration law is that the Dubai courts will be obliged to execute a domestic award which has been recognised in the DIFC. And that's true even if the award has not been ratified at the seat. But at the same time, if the award has not been ratified at the seat, the domestic courts will be obliged not to enforce. And you see that from Article 215 of the CPC, which is in tab 2. So the result of that, Your Honour, is that if the award has been ratified by this court, it has to be executed by the Dubai court. But if you look in tab 2, you'll see Article 215 of the CPC. And Article 215 says, paragraph 1, an award of the arbitrators shall not be enforced unless it is ratified by the court with whose clerk the award has been deposited. Such ratification to be made after perusal of the award and the arbitration instrument and an ascertainment that there is no obstacle to enforcement thereof, and the court shall have jurisdiction to rectify any material errors in the award of the arbitrators on the application of the persons concerned by the same means laid down for the rectification of judgments. So in other words, the ratification process is necessary before enforcement is permitted. And the ratification needs to be by the court which ascertains there is no obstacle to enforcement within the meaning of the CPC and which has jurisdiction to rectify the errors. So in other words, ratification under 215 has to be by the court at the seat. So in this case, we submit that has to be the Dubai courts because that is the seat of the arbitration. The DIFC court can't be the one which assesses whether there are obstacles to enforcement under the CPC. The DIFC court can't rectify the award. So the result is, in our submission, that enforcement is only permissible once it has been ratified at the seat. Now the other provisions, so that is apparent in my submission from 215 alone, but there are other provisions in the CPC which also in my submission show that it's the court of the seat which must ratify. If you go on page 4 to Article 2161, you'll see the parties, 2161, the parties may apply for the award of the arbitrators to be nullified when the court considers whether it should be ratified in the following circumstances. So, and then at C, if there is a nullity in the award or a nullity in the proceedings having an effect on the award. And then Article 2172, a judgment passed ratifying or annulling the award of an arbitrator may be appealed against by the appropriate avenues of appeal. And so decisions to annul or ratify an award are subject to an appeal as of right. So we say Article 215 is very clearly referring to the court at the seat ratifying first. Before then, the court cannot enforce. The words in 215 are mandatory. Shall not be enforced. The first line. And the problem is, if one construes the arbitration law as referring to domestic awards, you end up in a situation in which domestic courts are obliged to enforce the full ratification. So they are both obliged and not obliged to enforce. And the ultimate question is, can that really have been what the legislator intended in Article 42? And we say clearly not. Now, the position that domestic awards need to be enforced at the seat first is also a feature of Federal Law 11 of 1973. And that you'll find in tab 1 of volume 1.
In regard to this relation between the UAE Emirates?
Yes, sorry, I'm sorry, Your Honour. It's tab 1, page 4, article 13. The decision of the arbitrators issued in one of the Emirates shall be executable in any other Emirate member of the Federation. The juridical body being demanded to carry out the execution cannot reinvestigate the same incident concerning which the decision of the arbitrators was issued, but it can refuse to carry out the execution in any of the following cases. E. The decision of the arbitrators is not a final one, and I'm told that in the Arabic there's an extra passage which is in the emirate in which it was issued.
You have an Arabic version?
Yes, I can hand that up.
But the CBC, which issued after this law.
Yes.
And this law it was in 1973.
Yes.
And the CPC, which issued in 1992, and amended the last one, which is 2015. Do you think not override this law?
No, and I'll come to that. I'll come to the CPC in a moment. Let's take it in stages. This is still in force as a federal law.
You refer me to 13E?
Yes, 13E. So 13E, as obviously I'm afraid I can only speak to the English. The English version says the decision of the arbitrators is not a final one, but I'm told the Arabic adds in the emirate in which it was issued.
Yes, correct.
And that again assists in our point. We submit that final means enforceable. If you go on in this if you go to Article 12.5, sorry, just above 13, enforcement of a judgment may be refused where the judgment is not yet enforceable, not final, according to the law of the emirate in which it was issued. Yeah. And in this version it says, if the required decision to be executed did not gain the execution force, brackets, not final, according to the emirate issued thereof. So again, the point is that you have the general position that awards must be enforceable and therefore ratified at the courts at the seat before they can be taken to another emirate. So that, we submit, is the position. Now, that would be changed if domestic awards fell within Article 42 of the arbitration law. You could bring them straight to the DIFC court for enforcement. And that is exactly what WCT is trying to do. Indeed, they say that the ex parte order is a res judicata. Now, the award in issue in this case is a Dubai award. In other words, the parties to the contract have agreed that the seat of the arbitration is the Dubai courts, not the DIFC.
Can you show me this?
Yes, I think it's common ground. I'm sure we can find it. We'll dig it out.
Okay.
But I don't understand that to be disputed. It is not a DIFC award. The seat is not the DIFC.
No, but the parties agreed that the Dubai court is
the seat.
Yeah.
Yes,
it's a Dubai court.
Yes, I don't think that's in dispute, but we'll show you the provision. That's no problem.
But usually they agreed on the procedure law, the CPC, but they don't agree on the supervision or supervisory court as a Dubai court.
We'll find that in a second.
It's common ground that the seat of the arbitration was Dubai, outside the DIFC. I don't think my learned friend is making a submission that there was an express agreement.
To be Dubai court as a supervisory court.
No, all I'm saying is that the seat is the Dubai courts, not the DIFC.
No, the seat is Dubai.
Yeah, the seat is Dubai.
The seat is Dubai.
Now it's clear.
Yes.
Now it's
Okay. But our point, Your Honour, is this. If you follow the literal meaning of Article 42 of the arbitration law, you would also have to permit enforcement in the DIFC of awards from other emirates before they are ratified at that seat. So an Abu Dhabi award, for example. Before it's ratified, it would be enforcement would be permitted in the DIFC of such an award. And we submit that cannot be the meaning. Now, this court has heard similar arguments to this in the past, and my learned friend made the argument in X and Y that the arbitration law was unconstitutional, and I'll come back to that case in a moment. But in X and Y, the court said, well, these laws don't apply in the DIFC, so there is no problem with enforcement in the DIFC. Now, we do have some observations about that. We say that the provisions do apply, and in any event, Law 11 of 1973 does apply and wasn't considered in X and Y. But even if it's right, it doesn't solve the problem, because the problem arises in the Dubai courts. It is the inevitable result if you include domestic awards within the meaning of Article 42. So there is no question of the legislation being disapplied in Dubai generally. So our fundamental point is that if my learned friend's interpretation of Article 42 is right, you will get a conflict of legislation in Dubai.
Conflict of legislation with arbitration law and CBC? This is what you want to say?
And the federal law of 1973.
73.
Yeah. So you have a conflict of multiple laws, unless you can show that there is no conflict. On our submission, there is clearly a conflict in the provisions. And if Article 42 is interpreted in the way that my learned friend says, you have conflicting obligations. And that, we say, is why the ruler, His Highness the ruler of Dubai, could not have intended there to be a conflict in that way. Okay. And we say the answer is actually quite straightforward, which is that Article 42 doesn't include domestic awards. If you do include it, you end up with a conflict in the Dubai courts. And that is exactly where the court is permitted to look beyond the literal meaning of the words and decide that the legislator cannot have meant to include domestic awards. So at the heart of our case, to put it as simply as one possibly can, if my learned friend is right and domestic awards are included in Article 42, the Dubai courts have conflicting obligations. They have an obligation to enforce and they have an obligation not to enforce. And that cannot be right. And the answer is twofold. We say either it doesn't include, they're not, the primary answer, and I think in my submission the most obvious answer, is that Article 42 does not include domestic awards. Like in my car example, it's not the type of award that was intended to be covered by Article 42. And that actually is quite a simple solution. The result is, as we're asking for, that Article 42 does not include domestic awards. It's actually quite straightforward. It solves the problem, there isn't a conflict, and the reason for it is justified because of the problems that are created if that's not the solution.
Okay, if the seat of arbitration is DIFC, that you will change your position? That will be a domestic or international?
If it's a DIFC award, if it's a DIFC...
Within the same emirate?
Well, if it's a DIFC award, then it's the same court that has the process of enforcement and ratification and challenge. So it will be the court that deals with everything.
But you will consider it as a domestic award or international award?
If the seat is the DIFC, then it will be a domestic award. I'm told that it's actually not as clear as one might think, because the question is whether or not a DIFC award would be regarded as a New York Convention award. It's not part of my case, so I park that. The answer is, I'm told, not a clear-cut one in this jurisdiction.
Okay.
As I say, what we are concerned with is the specific issue, and the only issue that Your Honour is concerned with is a non-DIFC domestic award. That's the only issue, because that is where the conflict arises. The conflict arises in the Dubai court and the local court. So that is what Your Lordship is concerned with. Now, if Your Honour is with us in terms of the conflict, then in my submission it's actually a very short step to construe Article 42 in such a way as to exclude these awards. So far from being hopeless, the only reason it could be said to be hopeless is that you are compelled to follow the literal meaning of the words, and in my submission you're not. Now, what we do say is if that is wrong, and Your Honour feels compelled to give effect to the literal wording, then in that case you would have to, we say it's unconstitutional, and that's the other side of the coin. So if I can take you next to what my learned friend says about it. If you go to his skeleton, paragraph 7, page 7 rather, what he says about this is at 10.1. The second ground is based upon a purposive construction based on 5 allegedly undesirable consequences. Before considering each, it is important not to lose sight of the fact that the issue before this court on these applications is whether the arbitration law confers jurisdiction on the DIFC courts to recognise an arbitration award made within the Emirate of Dubai, not elsewhere in the UAE. Courts would be obliged to enforce and not to enforce. What it is supposed other courts may or may not be obliged to do cannot be an aid to the construction of the DIFC's jurisdiction within the DIFC. The argument proceeds on the assumption that WCT would take the award, if recognised within the DIFC, and attempt to enforce the award in Dubai outside the DIFC. That may or may not occur, but what may or may not be done outside the DIFC after recognition cannot logically determine what the DIFC court has jurisdiction to do within the DIFC. There is no basis for asserting that the DIFC court has no jurisdiction to recognise an award otherwise than in accordance with the CPC. This is held not to be the case. The judicial relations law is also irrelevant because it deals with the relations between the courts of different emirates, not between the courts of the same emirate. The suggestion that the Dubai courts would have no choice but to execute the award pursuant to Article 72 of the JAL, but at the same time would be obliged not to execute the award as a result of the same legislation does not withstand scrutiny. At its highest, Meydan's argument is the fact that there may be conflict between the duties of the Dubai court, not the DIFC courts, under the JAL and the CPC, but that cannot affect the jurisdiction of the DIFC courts. And while the matter of Dubai, not DIFC law, is wrong, it is for the Emirate of Dubai to regulate the procedures of its courts, both the DIFC and the Dubai courts, within the Emirate. And if the effect is that by reason of laws issued by the ruler, the Dubai courts are obliged to permit execution of an award recognised by the DIFC courts that has not also ratified by the Dubai courts, it is the ruler's prerogative to allocate judicial business between the courts as he sees fit. So that is their answer. Now, there are quite a few points in there. The first is that he says that the consequences in the Dubai courts are irrelevant. He says it doesn't matter what happens in the Dubai courts, they're completely irrelevant. What may or may not occur outside the DIFC, he says, cannot logically determine what the DIFC has jurisdiction to do within the DIFC. That's his case. Now, that is not right. The question is the interpretation of a DIFC law issued by the ruler. And the consequences of my learned friend's interpretation is that the Dubai courts will be placed under conflicting obligations by other legislation, part of which is also issued by the ruler, and part of which is federal law. So the consequence is still that the Dubai courts would be faced with conflicting obligations. And we say that is an extreme result which must be avoided, even if doing so means construing Article 42 in a way which departs from its literal meaning. So we say it's far from being irrelevant, it is highly relevant. And my learned friend says there is no basis for asserting that the DIFC has no jurisdiction to recognise an award otherwise than in accordance with the CPC. And this, he says, has been held not to be the case. And I think that may be one of the things that your Honour was adverting to. And he talks about two cases concerning constitutionality complaints. The first one is in Volume 1 of the authorities. At tab 26. Tab 26, it is the X and Y. It's Judge Arley. And if you go to paragraph 51, he says, paragraph 51 on page 11, the rules of the CPC are not applicable in the DIFC or before this court by federal legislation, Federal Law 8 of 2004, and that means there cannot practically be a conflict between an applicable rule and an inapplicable one. Now, that case concerned the enforcement of foreign awards. So the point we're making here couldn't have arisen in that case. And the conclusion was that the CPC does not apply in the DIFC. And we do take issue with that, and I'll deal with that in the second part of my application. But the point is irrelevant here. We are not saying that the DIFC court has to apply the CPC. We are saying that if you require the DIFC courts to enforce domestic awards before they have been ratified in the domestic courts, i.e. here in the Court of Dubai, the domestic courts end up facing conflicting obligations. So it's not relevant. It's relevant to constitutionality, and I'll come to that in the second part of my submissions. But on the first part, which is construction, what we are saying is that the Dubai courts will have conflicting obligations if you construe Article 42 in the way that my learned friend says you should. And we say that's a very powerful reason why it should not be construed in that way. Because if you construe it in that way, you are effectively saying the Dubai courts of the same state, have conflicting obligations. And we say it would take a very good reason to reach that conclusion. And that informs the way we construe the legislation. You construe it so as to avoid the conflict. You exclude the domestic awards. Now, what my learned friend also says, my learned friend says, well, Federal Law 11 of 1973 deals with inter-emirate enforcement. So he says, well, it's only about, between the emirates. So it's irrelevant here because you're concerned with the Dubai War. That's what he says. But again, that doesn't answer the point of principle. It doesn't deal with the clash which arises in the Dubai courts under the CPC. And secondly, it's about the interpretation of a statute. The facts of any particular case don't determine the meaning of the legislation. If you include domestic awards in Article 42, you include all domestic awards. On my learned friend's interpretation, this court would be obliged to enforce, for example, an Abu Dhabi award, applying the model law test before it had been ratified in Abu Dhabi. In other words, just because this case is about a Dubai award does not affect the question of principle of construction of Article 42. You would still have a clash, and that is why we say you shouldn't interpret Article 42 as including domestic awards. And finally, he says, it is up to the ruler of Dubai to decide how to allocate business between courts in Dubai. And to a certain extent, that is right. Up to a point, it is right. But the question is, what did His Highness intend? We cannot ignore the fact that different laws apply depending on which court is allocated. And if you interpret his legislation as allocating enforcement of an unratified domestic award, then he will have created a system in which his own courts, the Dubai courts, cannot comply and have conflicting obligations. And we say, yes, it is up to the ruler of Dubai to decide how to allocate business between courts in Dubai, but you have to interpret it in such a way that the ruler does not intend there to be conflicts given effectively to the courts of Dubai. And again, that is another reason why you have to, in our submission, interpret Article 42 in a way to avoid it. Now the second problem, so that's the first problem, clash. The second problem is executing while annulment proceedings are on foot. So the second problem is you end up with a situation where the DIFC court would be enforcing an award, and so the domestic courts could be called upon to enforce the same award at the same time that an annulment application was going on at the seat. So you're calling for enforcement here, and yet you have an annulment application in the Dubai courts. And in that situation, you end up with a clear potential for conflicting judgments. Conflicting judgments between the DIFC court and the Dubai courts, but also within the Dubai courts themselves. You will have execution procedures going on in the Dubai courts, and at the same time that those are ongoing, the court will be considering whether the award should be enforced at all. So there'll be two processes, and one in effect assumes the outcome of the other. And if the award is set aside, you have difficult procedural questions about what to do. Presumably, you would have to come back to the DIFC courts to get the original order set aside. And then you go back to the Dubai courts to unwind the execution. And all of those difficulties, you can see, Your Honour, that there are real difficulties about that process in practice. All of those problems are avoided if domestic awards are excluded from Article 42. And if I could take you back to Benyon, the leading work on interpreting statutes, which I showed you earlier, it's in bundle 2 of the authorities at tab 47. Page 16 of the bundle. Another rule
which tab again? Excuse me. Which tab?
Sorry, it's tab 47, page 16. Inconvenience in legal proceedings. Do you see that?
No, actually, I got a case.
Right, so it's second bundle, tab 47.
Which is the second bundle.
Authorities bundle.
Authority.
Yep. Tab 47.
47.
Yep.
Page 16, which is I got construction against absolutely, which is a case.
Yes, that's it, exactly. Halfway down the page is a heading in italics, inconvenience in legal proceedings.
Yeah.
Well, that's what I wanted to show you. Courts strive to avoid constructions that render legal proceedings unworkable. For similar reasons, courts seek to avoid unnecessary expense or other convenience to litigants or officers of the court. The paramount importance of reducing cost and delay of civil proceedings makes it necessary for judges sitting at first instance to assert greater control over the preparation for and conduct of hearings than has hitherto been customary. Thus, a construction requiring a litigant to pursue two different courses, two different approaches against decisions made on a single complaint will, if possible, be avoided. And the court will seek to avoid a construction which requires a litigant to pursue two different courses of appeal against decisions made on a single complaint. And that problem, that practical problem, is illustrated by the current position. There are currently other proceedings, as Your Honour knows, before the Dubai courts, which are well advanced. One of the issues in that case is whether time had expired for the arbitration. The Dubai court found at first instance that the issue was before the arbitrators, but the Court of Appeal found that it would be premature to decide the issue before there was an award. And in December, the Court of Cassation overruled the Court of Appeal decision and remitted the case to the Court of Appeal, finding that it had jurisdiction to decide the issue. So the Dubai Court of Appeal will be deciding that issue come what may. So you could see in this very case the practical difficulties which arise if Article 42 is given the meaning that WCT contends it should be given. And the problem arises whether the issues in the DIFC courts and in the Dubai courts are the same or different issues. Again, if you look at the current situation, there is an application to enforce here in the DIFC courts. There is an application to annul in the Dubai courts. The test for enforcement here is different to the test in the Dubai courts. But obviously the two tests overlap and have related consequences. So some of the issues before the DIFC court would be the same as some of the issues before the Dubai courts. For example, when I've given you the jurisdiction of the tribunal. Other issues would be only available in the Dubai courts, and I'll come on to that in a moment. But if the issues are the same or very similar, there is the clear potential for creating an issue estoppel. So, for example, if this court found that the tribunal had jurisdiction, or alternatively, that it did not have jurisdiction, that could be binding on the parties in the other court. And that is in principle possible. And the consequence of that is that there would be a race to judgment between this court and the Dubai courts. The parties would have to argue the issues twice. One here, one in the Dubai courts, and whoever got there first would be potentially creating an issue estoppel for the other court. And you've seen that in the document I showed you this morning, the very first document. They're contending there is a res judicata, binding on the parties, which can't be opened. Now that again is another very important consequence of which can be avoided if we're right on construction. And we say that issues such as these are far better for the court of the seat to decide. They're far better placed to decide those issues. And again, that race to judgment is a consequence which we say it's inevitable if you conclude that domestic awards fall within Article 42, and is wholly undesirable. It's it's expensive, it's unnecessary, it creates this race, it creates multiple lawyers being involved, multiple cases, multiple complexity, because not only do you have the race in each court, but the interplay between the two courts. So if my learned friend is right, you created this situation of complexity and a race to judgment. On the other hand, there are going to be issues which arise in the Dubai courts which don't amount to defences under DIFC law. So because it's the court of the seat where the challenge takes place in the Dubai courts, there are other defences. So for example, inconsistencies in a domestic award can give rise to a defence. You'll see that from the CPC. So if you go back, I'm afraid, to Volume 1 of the authorities, tab 2, page 4, Article 216 says, the parties may apply for the award of the arbitration to be nullified where the court considers whether it should be ratified. In the following circumstances, C, if there is a nullity in the award or a nullity in the proceedings having an effect on the award. Now that has been interpreted by the Union Supreme Court as meaning inconsistency. So a suitable case of inconsistency can give rise to a basis for nullifying the award. And you can see that, in fact, you're in a much better position than others. Because if you go to Additional Authorities, Volume 1, tab 15, you will find, I hope, the case in Arabic.
Additional document?
Yeah. Just in our authorities bundle, Volume 1, tab 15.
Same bundle.
Yes, same bundle.
Union Supreme Court judgment, right?
Yes.
So where's the additional? Tab 15 should be in the additional. Okay, thank you.
If you go to page 976, and if you could, in fact, if you could just read, 976 you should have box in red. I'll just ask you to read that box. So, in fact, the court must extend its oversight to everything that can lead to nullity of the award or insufficiency of the factual reasons thereof. And then in the following box, do you see in the box on 977? Let's read that. And then finally, just 978, which sort of builds on the insufficiency of reasons.
Okay.
So, and then I'm sure Your Honour is very well aware of these, but if you also could go to tab 45, which is in the second bundle. Which, this is a Supreme Court case from the 6th of January, and paragraph 34, which is should be in a box.
Again, the tab is?
Sorry, tab 45.
45.
It's
This is in a...
a Cairo Court of Appeal case,
Yeah.
6th of January. If you could go on to paragraph 34.
Yeah.
And you'll see the control of judiciary over the reasoning of the arbitral judgment, even if it does not require an examination or scrutinise the subject matter, it does not stop at the limit of apparent form. The reason of annulment is achieved if it is discovered upon reading the arbitral award accurately there is a tangible and prominent violation in its reasons, and this violation is vital and conclusive to the conclusion of the award. If the control of the annulment judge does not deal with the soundness of the reasons of the award, or their real legal value, because it is not an appropriate control, such fact does not prevent the annulment court to verify the existence of a clear violation in the award reasons, so as not to keep any of its basic elements with the existence of such violation, what upholds its verdict. And then it says at 35, in other words, the arbitral award is exposed to the annulment penalty if it is containing clearly illusionary or assumptive reasons, or mysterious, futile, contradicting, unlogical reasons which are not imposed by the facts of things. As long as these defective reasons are material and effective to the solution mentioned in the verdict, as long as the defect is latent in the reasons, which are considered the foundations of the verdict of the award rendered by the arbitral tribunal, the annulment judge has to control the challenge points and allegations directed to the arbitral award in this concern. Generally, there are no stringent limitations which limit the freedom of the arbitrator to reasons of award, nor to a certain shape or arrangement. However, it is necessary that reasons justifying the award should not deteriorate to a level of nonsense, contradiction, or bickering, which leads directly to demolish the legal structure of the award and waste its main pillar. No verdict may stand without such a pillar, as no reason will be able to support the award. Here, the award may be considered as uncaused. And there is also the case of full absence of reasons. So our point on this is that the position in the Dubai court and the DIFC court is different. There are other grounds on which the award could, for example, be rendered null and void. Now, so we say that in those circumstances, the Dubai court can review the merits of the award beyond mere form. Now, under DIFC law, of course, that is not allowed. The defences in Article 44 don't permit it because they're based on the model law and the New York Convention. So they don't allow a re-examination of the merits. And you'll see the difference in approach in another case, which is in the first authorities bundle at tab 19. So just going on, so back to volume 1, in tab 19.
This is Dubai Cassation Court judgment?
This is a, yes, Dubai Cassation, yes, 132 of 2012. And I only want to show you page 6 to show you that this was a London award. So just page 6, and it's the paragraph in the centre of the page, the court of first instance. If you could just read that to yourself.
Yeah, dealing with the New York Convention.
Yes, exactly.
And they consider it as an international award.
Exactly. That is exactly my point. So that is exactly what I was going to draw to your Honour's attention, which is the case concerned a London award. You can see that from that paragraph. The defendant raised a series of offences under the Civil Procedure Code, and the Court of Cassation dismissed the challenge because of the New York Convention defences applied. So the short point here is this, that if Article 42 is construed in the way my learned friends want it to be construed, and domestic awards can be enforced in this way, the defendant potentially loses its grounds of defence that he could advance in the Dubai courts. Now, that issue didn't arise in X and Y, because there the court was faced with a foreign award. And we submit, again, further point, the legislator, His Highness, simply cannot have intended to remove defences essentially granted by federal law by the implementation of the DIFC law. So if my own friends are right, they can come to the DIFC, they can get the award ratified and enforceable, and then the party who loses the possibility of bringing a challenge in the Dubai courts. So that is lost, and we say that that cannot have happened simply by means of the implementation of Article 42. That cannot have been intended. And the reason we say there are 3 points to be made in relation to that. There is a general principle that the legislator generally does not make casual changes to the existing legal structure. You interpret legislation to avoid radical change being made by assignment. And again, you see that again from Benny, and we'll go back to Benny in the statutory construction text. Back to Bundle 2 of the authorities, tab 47, at page 7. Section 269 in the box at the bottom of page 7. Section 269, tab 47, page 7. Section 269, law should not be subject to casual change. It is a principle of legal policy that law should not be altered deliberately, that law should be altered deliberately rather than casually, and that Parliament should not change either common law or statute law by assignment, but only by measured and considered provisions. In the case of the common law or acts embodying the common law, the principle is somewhat stronger than in other cases. It is also stronger the more fundamental the changes. The Court, when considering in relation to the facts of the instant case, which of the opposing constructions of the enactment would give effect to the legislative intention, should presume that the legislator intended to observe this principle. The Court should therefore strive to avoid adopting a construction which involves accepting that Parliament contravened the principle. And then it says, the section of the Code has been judicially approved. The principle that law should not be subject to casual change is an aspect of legal policy. For the nature of legal policy, see the Code, and as to opposing construction, see the Code. The presumption that Parliament does not intend to make a radical change of existing law by assignment arises from the nature of the legislative process. It is or should be a serious business. Changes in the basic law, since they seriously affect everybody, are to be carefully worked out. The more fundamental the change, the more thoroughgoing and considered should be the provisions by which it is implemented. Such is the proper way to conduct the legislative processes of a civilised state. One aspect of this is that the settlement of private rights should not be held to determine public rights. As we have mentioned, private rights give way to public. The principle is also expressed in the maxim, public rights ought not to be indiscriminately decided out of a private transaction. Where these requirements are not met, the suspicion is raised that perhaps, although the words of the enactment seem to point that way, Parliament did not really intend a radical change in existing law. Since it has not produced a text of appropriate design, any uncertainty in the wording should be resolved in favour of the less extreme meaning. As Devlin said, it is a well-established principle of construction that a statute is not to be taken as affecting a fundamental alteration in general law unless it uses words that point unmistakably to that conclusion. So, Your Honour, that's pretty powerful stuff. And we do say that the indirect effect of changing DIFC law in this way would be radical change to the enforcement of domestic awards throughout the UAE. And it would be radical change, we submit, by a side route, because there's nothing in the legislation that suggests that is the intended effect. And we would say, to the contrary, the presumption which arises from this is that the legislator, His Highness, did not intend this. So that's the first point. I mean, that, in my submission, is enough in itself. But the second point is that you favour interpretations which affect the least alteration to the law. And that you'll find in the same authority, just in the next page, at tab page 9, at the top of the page, the heading, Least Alteration Presumed. Where the legal meaning of an enactment is doubtful, it will be presumed, other things being equal, that it was intended to affect the least alteration of the existing law. So that, again, is powerful support for our construction. And the third point is that you strive for a construction which leads to consistency in the legal system. You avoid anomaly and try to ensure that similar cases are dealt with in the same way. And that you'll find a little bit further on at page 21 in the same tab. See, in the middle of the page under the heading Benefit Not Available in Like Cases, consistency requires that a statutory remedy or other benefit should be available and should operate in the same way in all cases of the same kind. Now, if you include domestic awards in Article 42, you have two courts in the same legal system dealing with domestic awards in a completely different way. And a similar issue, we put in our skeleton, a similar issue has been considered by the European Court of Justice, but in the context of the enforcement of justice, of judgments. And it's a well-known case called Owens Bank and Bracco. And Your Honour will be aware that within Europe there is essentially a judgments regulation which regulates how judgments between states are to be enforced in other states. And the question arose in that case, and I'll come to it in a moment, but let me just tell you what it's about first. The question arose was whether when you enforce a judgment in a European state, what you get at the end is whether what you get is a judgment which falls within the regulation. So let me give you an example. You have a judgment in London which is taken to Spain, and then you get a ruling from the Spanish court on the London judgment, and then you can enforce it in Spain. And it would happen in any. That's the issue of principle. And the question for the court is that judgment of the Spanish court, i.e. the second judgment, the judgment on the judgment, is that a judgment? And posing that question, it's very similar to the question here on Article 42. Is a domestic award an award for the purposes, a non-DIFC domestic award, an award for the purposes of Article 42? And here in Owens Bank and Bracco, the question was, is a judgment enforcing a judgment for the purposes of the convention? Now the literalist would say, of course it is, because it's a judgment. And it's about judgments, and it's a judgment regulation. The Spanish court has given a judgment, or it could be the Italian court, the French court. They have given a judgment. And the literalist would say, that's the end of the story. That's a judgment. But that's not what the ECJ held. They said, it's not a judgment for the purposes of the convention. So they departed from the literal meaning of judgment. And part of the reason that they did that is because you could then essentially forum shop. You could go to another country which had the lowest test for challenging a judgment, and always enforce there. And then you could use that to go everywhere else. So what you would end up doing is a process of forum shopping to go wherever the least hurdle is. And if you go to tab bundle 2, tab 36, you'll find the case there. And I just want to take you to paragraph 22 first of all. This is a judgment of the Advocate General. Sorry, opinion of the Advocate General. At 22 it starts. The same applies in relation to recognition and enforcement of the judgments of the courts of non-contracting states. A decision by a contracting state whereby a judgment of a non-contracting state is declared enforceable takes effect only in that contracting state. Where the judgment of the non-contracting state is also to be enforced in another contracting state, the judgment creditor must apply to the courts of that contracting state for declaration that the judgment of the non-contracting state is enforceable in that contracting state. Both cases concern proceedings governed solely by the law of the contracting state in question, including any conventions existing between that contracting state and the non-contracting state. On the other hand, Title 3 of the Brussels Convention does not apply to these proceedings. This means, in particular, that the decision of contracting state A, by which the judgment of the non-contracting state is declared enforceable in that contracting state, cannot be enforced in contracting state B under Article 31 of the Convention. And then this is a particularly important part of the judgment. To permit such double execution, opinion. To permit such double execution, I stand corrected. To permit such double execution would, as the United Kingdom has rightly pointed out, create the danger that a judgment creditor could circumvent the conditions laid down by a contracting state for the recognition of judgments of the court of the non-contracting state in question. If, for example, contracting state A makes the recognition and enforcement of a judgment of the courts of a non-contracting state conditional on certain criteria, whereas judgments from that non-contracting state are declared enforceable unconditionally in contracting state B, the judgment creditor could first obtain a declaration of enforceability in contracting state B, and then under the Brussels Convention, enforce the judgment without difficulty in contracting state A by virtue of the decision obtained in contracting state A. In other words, you can avoid the conditionality by going to the other state which doesn't require it. I share the United Kingdom's view that it is not the aim of the Brussels Convention to enable judgment creditors to engage in such forum shopping. And in the judgment itself, so that's just the opinion, well I say judge, but that's the opinion of the Advocate General. But if you go to the judgment itself at page 546, you will see paragraphs, it's dealt with at paragraphs 30 to 33. Secondly, according to Articles 27 and 28 of the Convention, read in conjunction with Article 34, the question whether any such ground exists in the case of judgments given in another contracting state falls to be determined in the proceedings in which the recognition and enforcement of those judgments are sought. There is no reason to consider that the position is any different where the same question arises in proceedings concerning the recognition and enforcement of judgments given in non-contracting states. On the contrary, the principle of legal certainty, which is one of the objectives of the Convention, militates against making the distinction advocated by the defendants. The rules of procedure governing the recognition and enforcement of judgments given in a non-contracting state differ according to the contracting state in which recognition and enforcement are sought. So the point was, if you allow enforcement of judgments on judgments in that way, a party could choose the point of entry with the least offences and so avoid the defences that they would have to engage with at the ultimate destination. And we submit that is exactly what WCT is trying to do here. They are trying to apply a lower hurdle in this court, lower and different from that which would apply in the Dubai courts. And so if you apply Article 42 to domestic awards, you allow enforcement in circumstances where it wouldn't previously have been allowed. In effect, you change the law of enforcement of domestic awards throughout the UAE. And that, we say, is not something that could have been intended. So, just as in Owen's Bank, the ECJ excluded certain types of judgment, and so departed from the natural meaning of judgment, here the courts should exclude certain types of award, namely domestic awards, and depart from the literal meaning of the statute. Now, the problems associated with having annulment and enforcement proceedings going on under two different laws with different legal tests are very serious, and we submit they are very strong reasons to exclude domestic awards from Article 42. Now, what does my learned friend say about this in his skeleton? He says very little, and if you just go to his skeleton, pages 8 and 9, it's dealt with at paragraphs 10.2 to 10.4. It's page 8 of 29. So he says, non-DIFC domestic courts required to execute awards while annulment proceedings are on foot in the courts of the same area. This is not a point that can go to jurisdiction, as it is expressly catered for by the arbitration law, as set out in paragraph 3 above. Issues the same, issue estoppel. This is another way of phrasing the proceeding point. If an award is being challenged at the seat, the award debtor may seek adjournment of the recognition and enforcement proceedings in the DIFC. This is not a point going to jurisdiction of the DIFC courts. And 4, different issues, avoiding the federal test for enforcement. This is yet another way of phrasing the same point. There is no anomaly that impugns the DIFC court's jurisdiction. So taking those in order, on the first point he refers back to paragraph 3, where he says what we should have done is apply for an adjournment. But that is not a solution. You still end up with a conflict in the Dubai courts, if he's right. You just give the defendant an opportunity to prevent it, and they may or may not do so. There will still be the prospect of a conflict in every case. You will still have both courts in the same state considering the same issues. This court would need to look at the merits of the annulment application in deciding whether to stay, and if so, on what terms. And you still have the prospect of conflicting decisions. You still have two courts in the same state applying different legal tests to the same problem. And you still get to a situation where the defendant is deprived of defences. You also introduce a security requirement in any case where the claimant opts to apply to the DIFC courts. Now, my learned friend says that security is not a condition of pursuing a challenge at the seat, but we say, in practice, it would be. If you don't pay the security, they can enforce the award before your challenge is ever heard. So you still end up with significant change to the law of enforcing domestic awards by a side route. And my learned friend emphasises that the English courts examine the merits of the challenge at the seat when deciding whether to grant an adjournment. And he says in his skeleton that this is done in 156 New York Convention states. Now that is a very bold claim to say that that is the process which is adopted in all of the 156 New York Convention states. But even if it's right, you can see that the need to do that, where the seat might be, for example, in Nigeria, as it was in one of the cases, and the challenge could take years, sometimes even decades, you can see the need to take that approach in such jurisdictions. But here, the challenge is in the courts in the very same state. And where that applies, it makes no sense at all. There are already courts in this country, in this emirate, looking at the award. There is no requirement under Dubai law to pay security as a condition of that challenge. And by this roundabout route of claiming in the DIFC courts, the claimant can impose the security requirement, which does exactly that. And again, we say that cannot be what the legislator intended. Now, to emphasise that point, that the legislator doesn't intend to bring about radical change to the law, it is worth looking at the position it was, as it was before the arbitration law was enacted. At that time, the legislation only permitted direct enforcement in the DIFC courts of DIFC awards and foreign awards. Domestic awards from Dubai, for example, had to be ratified by the courts of the seat before they could be enforced. And at that stage, there were three relevant pieces of legislation. There was the original judicial authority law, before it was amended in 2011. There was the court law, and there was the New York Convention once it was introduced in 2006. And I just want to take you briefly to each of those. The first one is in the first bundle of our authorities at tab 13. This is the court law, and page 11 is Article 24, and the enforcement of judgments falls under Article 24. If you see 24, ratification of judgments. Pursuant to Article 7.4 of the Judicial Authority Law, the Court of First Instance has jurisdiction to ratify any judgment, order, or award of any recognised, and then you go to C, arbitral award, D, foreign arbitral award. Now the language is a little bit confused because it refers to an award of any recognised arbitral award. It doesn't really make much sense. But two things are clear. The power to enforce an award under Article 24.1 arose pursuant to Article 7.4 of the JAL, which is exactly how it opens, pursuant to Article 7.4 of the Judicial Authority Law. And second, foreign awards were covered by Article 24.2. If you go to the page, where the UAE has entered into an applicable treaty for the mutual enforcement of judgments, orders or awards, the Court of First Instance shall comply with the terms of such treaty. Now, that implemented in shorthand treaty obligations, including the New York Convention. But when it comes to domestic awards, they can only be enforceable under Article 24.1. So we have to look at Article 7.4 of the JAL to see what it meant. And that should be in tab 9A of your bundle. Do you have tab 9A? If you go to Article 7, which is on page 4, so under Article 7, the enforcement. Should the subject of execution fall within the centre, judgments, awards and orders issued by the court and arbitral awards ratified by the courts shall be enforced by the executive judge of the centre. Should the subject of execution fall outside the centre, judgments, awards and orders issued by the courts and arbitral awards ratified by the courts shall be enforced by an executive judge of Dubai courts, subject to the following. A, the judgment, award or order is final and is appropriate for enforcement, and B, the judgment, award or order has been translated into Arabic. 3, the executive judge of the Dubai courts has no jurisdiction to review the merits of a judgment, award or order of the courts. 4, judgments, awards and orders of any court outside the centre may be enforced within the centre in the manner prescribed in the centre's laws. So Article 7.4 permitted enforcement in the DIFC of judgments, awards and orders of any court outside the centre may be enforced within the centre in the manner prescribed in the centre's laws. So only awards of any court outside the centre may be enforced in the DIFC. So that must mean in our submission awards which have been ratified by another court. And that follows from the way the same phrase is used elsewhere in Article 7. So if you look at 7.1, 7.1 deals with judgments issued by the DIFC courts and arbitrary awards ratified by the DIFC courts. 7.2, where the subject of execution is outside the DIFC, judgments issued by the DIFC courts and arbitrary awards ratified by the DIFC courts may be enforced in the Dubai courts. 7.3, the wording is important. The executive judge at the Dubai courts has no jurisdiction to review the merits of a judgment, award, or order of the courts. So there the phrase award of the courts means, in our submission, awards ratified by the courts. So when the same words are used in 7.4, awards of the courts, it's talking about awards ratified by the domestic courts. The result is that Articles 7.4 and so Article 24 of the court law only permitted enforcement of awards which had already been ratified by the domestic courts. Now, my learned friend says this is a strange interpretation. It isn't. The only alternative is that 7.4 literally means awards issued by courts, but there aren't any. So 7.4 wouldn't permit enforcement of domestic arbitrary awards at all. So we say, quite clearly, the position before the arbitration law was that domestic awards had to be ratified before they could be enforced in the DIFC courts. Foreign awards were different. They could be enforced under Article 24.2 of the court law because there was a treaty obligation. So the next thing that happened was that the DIFC arbitration law was brought into force. So we have Article 42, which is at the heart of this case. And then the judicial authority law was amended in 2011. And the reference in Article 24 of the court law became a reference to the new provisions in Articles 7.4 to 7.6. And we know from the DNB Bank and Gulf Ayada case that those provisions carefully refer only to awards which have been previously ratified by the Dubai courts. So if you go to Bundle 2 of the authorities, tab 31, page 9, judgment of Judge Ali, at paragraph 30. This is just to show you the movement. Paragraph 30, I reject the assertion Article 7.4 of the judicial law.
Just for which
tab 31. Tab 31 in the second bundle.
Yeah. I think this case has been appealed, right?
Yes, but not on this point. That's correct.
Yeah.
I'm only really showing you for the last sentence, which is according to the reference into Article 7.4 in Article 24.1 of the court law must now be a reference to Articles 7, 4, 5 and 6 of the Judicial Authority Law number 12 of 2004 as amended by Law number 16 of 2011. So just to show you that that is what was held in that case. And then if you go back to the other bundle of authorities at tab 9,
Article 7?
so yes, Article 7, it's all in the red box, but I want to show you Article 7.4, page 5,
Yeah.
where the subject matter of execution is situated in the DIFC, the judgments, decisions and orders rendered by the Dubai courts or arbitral awards ratified by the Dubai courts shall be executed. Then in Article 7.5, it also refers to arbitral awards ratified by Dubai courts. And then Article 7.6 refers to ratified arbitrary rules. So the upshot of all of that is that prior to the implementation of the arbitration law, you had to get your domestic award ratified first before you could enforce it in the DIFC courts. Now, after the arbitration law came into force, the ruler amended the judicial authority law in a way that is totally consistent with that position. There is nothing here which suggests that the position might have changed. In fact, it's in my submission, it's clearly the same. You can still only enforce ratified domestic awards. The question is, how likely is it that despite this, the legislator nevertheless intended to effect fundamental change to that machinery? And we would say it is very unlikely indeed, because you offend against the principles of construction we've identified. Legislators don't effect radical change by a side wind. You don't create two systems for doing the same thing in two different ways. You don't create conflicting obligations in the local courts. And against all of that is the point there is simply no need for domestic awards to be included in Article 42. The judicial authority law provides for the DIFC courts to enforce awards previously ratified in other UAE courts and vice versa, and there is simply no need to legislate for their direct enforcement in this court. Foreign awards are covered by the New York Convention. Both they and DIFC awards fall within Article 42, so you have a complete regime for enforcement of awards without the need for introducing direct enforcement of domestic awards. And as we have said, if you do allow that, you change the law significantly. You deprive the defendants of defences, you multiply legal proceedings and increase the cost and the risk of inconsistent judgments, and you put the local courts in the position of facing conflicting obligations. And you can avoid all of that without losing anything at all if you construe Article 42 as excluding domestic awards. And you asked me about DIFC awards. Now that isn't part of our case, but I just want to make our position clear. A DIFC award is a domestic award. It doesn't matter what label you give it, but the conflict only arises if you include non-DIFC domestic awards. So that's why this issue focuses on non-DIFC domestic awards.
But again, we're going to apply the Article 42 here, correct?
Yes, correct. Correct. But what we're saying is that you exclude from Article... The only issue on this application is whether you exclude non-DIFC domestic awards. And that's what we say you do. That's the only issue that Your Honour is concerned with. Is should they be excluded or are they included in 42? Non-domestic DIFC, non-DIFC domestic awards. Now, it makes sense to say that the DIFC award is not considered a domestic award. We say Article 42 does apply to DIFC awards, and we say that at paragraph 110 of our skeleton, and there are good reasons for saying that. The model law applies, and the CPC for non-DIFC domestic awards. But what Your Honour is concerned with in this case is non-DIFC domestic awards. Now, those are my submissions in terms of construction of Article 42. And we say that all the problems can be avoided if you construe it in the way that we say it should be construed. The flip side of that is if we're wrong, and we submit very strongly that we're not wrong, then constitutionality issues do arise. And I'll come to that in a moment. But before I do, there is another issue which we've raised in our skeleton, which is a very fundamental issue, and it's very important to my client. And that is this, that if you want to enact legislation which creates jurisdiction in the DIFC courts, or which affects rights outside the DIFC, you have to do that in Arabic. It's a very fundamental point. The power to legislate comes from the Constitution. And I'll just show you where that is. It's Bundle 1, Tab 3, page 28. And if you go to Article 121.
Article 121.
Yeah. So, it's worth just pointing out 119 while you have it open, which is what matters pertaining to the execution of judgments, judicial delegation, serving legal documents, and the extradition of criminals from an emirate of the UAE to another shall be regulated by federal law for the purpose of facilitating these matters. And then you have 120 under the heading distribution of legislative, executive, and international jurisdictions between the UAE and the Emirates. And Article 120 sets out the UAE has exclusive legislative and executive jurisdiction in the following matters, and then sets them out: foreign affairs and so on, defence, protection, security, and so on. And all 19 of those. Then Article 121 sets out the areas in which the union may legislate. So they're all set out in Article 121. And then Article 122, the Emirates shall have jurisdiction in all the matters not conferred exclusively upon the federal authorities as provided in the two preceding articles. Now, the Constitution is a treaty, and so it has to be interpreted as such. And in interpreting it, you have to apply general principles of public international law. One of those principles is legal certainty, and to be effective, laws need to be known and understood. And that's reflected in Articles 112, 111 and 112 of the Constitution, which you'll find at page 25. Which say, law shall be published in the official gazette of the UAE within a maximum of 2 weeks from the date it is signed and issued by the President of the UAE, after it is ratified by the Supreme Council. Such law shall come into force after 1 month from the date of its publication in the official gazette, unless another date is stipulated in the law itself. And then Article 112, a law shall only apply from the date it comes into force and shall not apply regressively. In non-criminal matters, a law may, when necessary, provide otherwise. And then if you go back again to Article 7, you will see Article 7, Islam is the official religion of the UAE. The Islamic Sharia is a main source of legislation in the UAE. The official language of the UAE is Arabic. Now, the judicial authority law was published in Arabic, and the arbitration law was not. Now, the judicial authority law can be expected to affect those outside the DIFC, but the arbitration law...
You want to say all DIFC laws are unconstitutional?
No.
Yes.
Well, no, I'm not saying that. And he knows, my friend knows I'm not saying that. We have the point is this, it's quite a difficult issue. The question is this: in what circumstances must the laws be published in Arabic? And in what circumstances must they not be? There must be an answer to that question. Now, we have accepted in our skeleton not every law in the DIFC must be published in Arabic. Some can be published in English if the circumstances suggest that it's appropriate that it should be in English. The question for the court, and it's an important one, a very important one, is in what circumstances does it have to be promulgated in Arabic?
Now you remind me about the Federal Law number 1, 1973,
Yes.
which is in regard to the Gazette, official Gazette.
Yes.
I think on the break I will have to look at it, which is defined that each emirate has to issue their legislation.
Right. Well, that would be very interesting. Now, so the position in principle is this: in order for it to have an effect as law, it has to be published in Arabic in the official Gazette. And if it's not published, we say then that is a very good reason to construe the arbitration law in a way that doesn't reach outside the DIFC. Because if it's purely internal to the DIFC, one can understand the principle and logic of having the laws promulgated in English alone. But once it has an effect outside the DIFC, we submit that it should be in Arabic. Now, so what my learned friend says in his skeleton is all DIFC laws affect people outside the DIFC if they do business with a centre establishment, if they enter into a contract that may be performed in the DIFC, if they commit a tort relating to DIFC activities, or they agree to the jurisdiction of the courts. But we submit that all of those things involve a voluntary engagement with the DIFC. Here what is happening is that if you include domestic awards in Article 42, parties and relations which have nothing to do with the DIFC are brought into the DIFC. And that's the difference of principle. And that's another reason why we say that the legislator did not have that intention. What my learned friend says is, well, we concede that not everything has to be in Arabic, and they don't agree where we draw the line. But a line has to be drawn. One has to have a principle by which certain laws are in Arabic and certain laws are not. And the question is, where is that line drawn? And we say it's a very, very good, we're not saying it's unenforceable, what we're saying is a very, very good reason to limit the arbitration law to, in the way that we say, to exclude non-DIFC domestic awards. Because that way it concerns only those that have somehow engaged with the DIFC court itself. So it's a very important point of principle. And we submit, it gives further, we don't need this point, it's an extra point, but it's very important to my client to have a principled basis upon which it's understood which laws should be in English and which laws should be in Arabic.
And do you think Union Supreme Court, the best forum to distinguish the IFC court laws is constitutional or not?
This is a question about, I'm just about to come on to constitutionality, because that's the next issue, which is, before I go on to that, I do want to deal with one point in my learned friend's skeleton, which he says that all of the arguments are subject to what he says is a fatal flaw. He says we confuse the finality of an award with the question of whether it is binding. Now that is simply wrong. It is right that one of the defences to enforcement under DIFC law is that an award is not yet binding. And I'll show you where that is. That's in, if you've got it open, Bundle 1 of the authorities, Bundle 2 of the authorities, tab 11. Volume 1, at tab 11. It's the arbitration law.
Volume 1, tab,
Yes.
tab 11?
Tab 11,
Yeah. Page?
Article 44, page 19.
44.
Yeah. You'll see, recognition or enforcement of an arbitral award, irrespective of the state or jurisdiction in which it was made, may be refused by the DIFC court only, and then subparagraph A5, at the request of the party against whom is invoked, if that party furnishes to the DIFC court proof that 5. The award has not yet become binding on the parties, or has been set aside or suspended by a court of the state or jurisdiction in which, or under the law of which, that award was made. Now, the point about that is you don't get to that point unless you have an award which falls within the provisions of the Act. And I'm not raising any argument that the award is not binding within the meaning of the provision. Our point is that a domestic award is not covered by Article 42, so you don't have any jurisdiction to enforce it directly. You only enforce it if it's been ratified by the domestic courts, and that is a question of construction of Article 42. So all of the discussion on the meaning of binding is irrelevant. The point is that the laws applicable in Dubai already have a system for deciding whether a domestic award should be enforced or alternatively annulled. The legislator did not intend to change that, imposed by a roundabout route of using the DIFC courts, a different mechanism and a different set of rules. And that would be the effect of my learned friend's position. So Your Honour, that is the position in terms of construction. So all of those arguments are directed to our arguments in terms of what Article 42 means and how it should properly be construed. And in a sense, all of the problems, if you're with us on that, and that's our primary case, if all those problems fall away, all the issues about the difficulties and so on, they all fall away. Now, I therefore turn to constitutionality, and that is, these submissions that I'm about to give you are on the basis that we're wrong, and that you construe Article 42 to include non-DIFC domestic awards. And what is the position then? And that's only therefore if you consider that the language of Article 42 drives you to the conclusion that domestic awards are included, and then there is a conflict of legislation. And we say that the result of that conflict is that these proceedings should be stayed and the conflict should be referred to the USC. And that conflict arises in the three ways which we've already explained.
Actually, if you are aware of the Union Supreme Court judgment, it must be there's two judgments, which could be negative or could be positive.
Yes.
Which drive me to, I have to issue my judgment. I cannot postpone that if you're willing to take it to the Union Supreme Court.
Yes.
As a DIFC court, I have to issue a judgment, and same time, Dubai court have to issue their judgment, and must be both judgment could be taking their jurisdiction or avoid their jurisdiction, which is negative or positive jurisdiction. Otherwise,
Yes.
The Union Supreme Court will reject your case.
I understood. I'm going to explain what we say about that. Obviously, I'm going to deal with that. But what we say is that the conflict arises in three ways. So there is an obligation to enforce under DIFC and Dubai law, and not to enforce under federal law. Secondly, there is a conflict between the federal law and the DIFC tests for enforcement. And thirdly, there is a law which the Constitution requires to be published to be effective, but which has not been properly published. So those are the three conflicts that we're dealing with. And in X and Y, Judge Ali found that there was no conflict of legislation. So that's the first issue that we accept we have to deal with. And he said that was because civil and commercial laws had been disapplied in the DIFC. And you'll all should be aware of that. And the Court of Appeal said something similar in a different context, in IGPL and Standard Chartered. Now, I don't need to take your honour to those, but we say you're not prevented by those cases from considering the point here. First, it's because the issue is whether or not certain federal laws have been disapplied by other federal laws. And that is a question of UAE law, not DIFC law. There is no binding precedent, and it's rather like public international law in English law. Public international law is a part of English law, but decisions on it are not binding in subsequent courts. And I'll show you where we get that. It's a very short passage, but it is worth looking at. It's in the second bundle of authorities at tab 37, and it's the judgment of Lord Denning in Trentex Trading and Central Bank of Nigeria. It's a very famous case. And I just want to show you one paragraph on this quite complicated case, which was concerned with public international law and its effects in English law and the English common law doctrine of precedent. And if you go to page 26 of the bundle, or page 554 of the judgment, you'll see a paragraph at the end which says conclusion on this point. Seeing that the rules of international law have changed and do change, and that the courts have given effect to the changes without any act of Parliament, it follows to my mind inexorably that the rules of international law, as existing from time to time, do form part of our English law. It follows too that a decision of this court as to what the ruling of international law 50 or 60 years ago is not binding on this court today. International law knows no rule stare decisis. If this court today is satisfied that the rule of international law on a subject has changed from what it was 50 or 60 years ago, it can give effect to that change and apply the change in our English law without waiting for the House of Lords to do it. So that was quite a radical decision in some ways. So Your Honour is not bound by that decision on that point in other cases. Secondly, neither case considered whether Law 11 of 1973 was disapplied. And you recall I took you to that. It was part of the basis on which we say there would be a conflict of legislation. That law was not considered. Thirdly, neither of the decisions concerned an attempt to enforce a domestic award. X and Y was about an English award. IGPL was not about arbitration enforcement at all. So we say the issue is open to Your Honour. And what we say is the relevant laws are not civil and commercial at all. They are matters of public order. And so if you go...
What you refer to the Union Supreme Court Law 11 to 1973?
Yes.
This is the one that you refer to?
Yes, that is... it's the Law of Judicial Relations, which stands in it.
Yeah, 1973.
Yes.
And this is the authority which you asked me to apply to transfer this case to the Union Supreme Court?
That's 10. That's tab 10. Sorry, Law 10, sorry, which is tab 2. The one I'm referring to, if you look in the bundle, the law I'm referring to, Law 11 of 1973, is in tab 1. And I think the one your Lordship's referring to is Union Law 10 in tab 5, is that right?
Yeah, but my question is, you asked me to refer this case to the Union Supreme Court to determine the Constitution, the IFC law Constitution. Exactly your point, because I misunderstand you on this point.
Yes. What we say is that there is a conflict, and the court should refer the issue to the UFC on the conflict and stay the proceedings in the meantime. That's essentially what we're asking.
Right. In which authority I can refer this case to the Union?
Yeah, I'm going to take you. Can let me take a note. We'll get through that. If there's anything left at the end, I think it's better if we take it in stages.
Go ahead. Sorry to...
No, not at all. That's absolutely fine. I want to answer all of your questions because this is a very important point. If we start with tab 3 of volume 1.
Okay.
Which is the Constitution, and you go to Article 119, which is at page 27. The starting words of Article 119 are matters pertaining to the execution of judgments. So union law regulates matters pertaining to the execution of judgments, and they're designated as matters for federal law. So it must be right that certain federal laws continue to apply. Now, in X and Y, Judge Ali found that the Law 10 of 1973 did apply in the DIFC. If you go on in Bundle 1 to tab 26, at page 10 of the judgment, says there, 44 and 45, I also agree with the defendant's submission that the DIFC regime is not exempted from the jurisdiction of the USC when it comes to the constitutionality examination, including the fact that the DIFC court is a UAE court that can refer a matter to the UFC if requested to do so, and then must comply with the decision of the USC rendered in that connection. The text of Article 55 of the USC law suggests that a mere application by parties is not sufficient to refer the challenge of constitutionality to the USC. The court must first agree that the application should be submitted. If the challenge of constitutionality is raised through the plea of one of the litigants in the lawsuit and accepted by the court, it shall fix a term for the challenger to submit his challenge to the Supreme Court, and if the term expires without the submission by proof by the challenger that it's lodged its appeal in time, it shall be considered as having relinquished it. This means that the court has the capacity to consider the merits of an application and determine whether a conflict exists between two or more laws that fall under the jurisdiction of the USC. But the question remains to what extent the referring court's views should stand. And then, while I'm in it, I should just read on. So this means the court has the capacity to consider the merits. 47. The answer to this question can be found in case 134 of 2008, presented to this court by the defendant at the hearing. The court has the authority to evaluate whether the pleading of non-constitutionality is serious or not. That leads this court to the conclusion that the party pleading a challenge of non-constitutionality of a certain law must plead before this court to a certain level of seriousness. And that, in my view, should be the same level as will be pleaded before the USC. So you don't need two conflicting judgments. And I'll show you why not.
This is a question of constitution.
Yes, yes, absolutely. Engages that. It engages public order issues.
But I have to refer it.
Well,
I have to issue a judgment to refer it to the Union Supreme Court.
Yes. Yes, we would say yes, provided you're satisfied that it's sufficient.
And my question earlier was, under which law I have to do it?
Well, yes, Law 10. So.
Okay, go ahead.
Sorry, yes. No. So we say, in that case, Judge Ali applied the Union Supreme Court law. So some laws survive, and those, particularly those which are constitutional in nature. And we say Law 11 of 1973 must at least fall into that category, because it governs essential elements of the relationship between the Emirates, in particular service of process and enforcement of judgments and awards. And those are matters expressly reserved to Union law under Article 119. So Dubai cannot refuse to execute Abu Dhabi judgments or awards at all in the DIFC. You can't, in the DIFC, pass a law tomorrow which says no judgments or awards from other Emirates will ever be enforced. You're bound to enforce them, and that's because the law governing those things are not pure civil and commercial matters. They are public order matters. And my learned friend's submission is that the ruler can do whatever he likes so far as enforcement of arbitration awards is concerned within Dubai. And we say that is a very extreme position and is wrong. There are obligations owed to other Emirates to enforce their judgment and awards under the Constitution as a matter of public order. So the ruler has great powers, but he can't act. He is bound by those obligations, those fundamental constitutional obligations. There are obligations owed to other nations under the New York Convention and other treaties like the Riyadh and GCC conventions. They are all public in nature. And my learned friend says in his skeleton, the judicial relation law regulates relations between the courts of individual Emirates. Those sorts of rights, we say, the rights of each emirate as against one another, are constitutional in nature and so are not disapplied. So that's a very fundamental point. The second point is that the effect of the legislation extends beyond the DIFC. So the problem is ultimately the combination of DIFC laws and the judicial authority law. You can't just look at each element individually when it's the two that together create the problem. And what my learned friend says is, well, Law 11 of 1973 doesn't apply here because we're dealing with a Dubai award. But the point is that if, contrary to our prime position, arbitration law applies to all awards, including domestic awards, then it applies to awards from other emirates. It's a point of principle. We're not constrained by the fact that this is a Dubai award and you're dealing with that, because the point we've raised is such a fundamental one. It's a fundamental point of principle. And you have a clash of legislation if, contrary to our primary case, the literal meaning, so-called, is to be preferred. But under the CPC, you can have a clash of legislation anyway, whether the award is from Dubai, Abu Dhabi, or any other emirate. When there is a conflict, the court should refer the issue to the USC and stay the proceedings in the meantime. And if I can just show you Article 151 of the Constitution, tab 3, page 34, the provisions of this Constitution. Article 151. The provisions of this Constitution shall prevail over the constitutions of the member emirates of the UAE. The federal laws which are issued in accordance with the provisions of this Constitution shall have priority over the legislations, regulations and resolutions issued by the authorities of the emirates. In case of conflict, that part of the inferior legislation which is in conflict with the superior legislation shall be rendered null and void to the extent that removes the conflict. In the case of a dispute, the matter shall be referred to the Federal Supreme Court for deciding thereon. So where there's a conflict of legislation, it should be referred to the Union Supreme Court. And if you just move on to tab 5, which is the Union Supreme Court law, at page 13, Article 58 at page 13. You'll see there, requests for constitutionality to be raised before courts in respect of a case being tried by such courts shall be referred to the Supreme Court by virtue of a grounded decision from the court to be signed by the President of the competent circuit. Such decision shall have the text to be examined if reference is made upon a decision from the court out of its own accord. Whereas if the challenge of lacking constitutionality is raised to the plea of one litigant in the lawsuit, and the court has admitted such challenge, he shall fix a term for the challenger to submit his challenge to the Supreme Court. If that term expires without the challenger having submitted evidence indicating that he has lodged his appeal in time, he should be considered as having relinquished such plea. If the court rejects the plea, the rejection should be pursuant to grounded judgment. The concerned parties may challenge that rejection along with the decision to be issued on the merits of the case before the court that has jurisdiction to examine the appeal to such decision as long as the appeal thereto is admissible. The court before which the action is examined shall order stay of the proceedings thereof until the Supreme Court decides on the matter of constitutionality. The stay decision shall be issued with the referral decisions referred to in the first paragraph of this article or following lodging the appeal within the term fixed by the court as stated in the second paragraph. So, if you raise a challenge in the lawsuit, if appropriate, the court will refer the issue to the Union Supreme Court. And my learned friend appears to accept this insofar as Law 11 of 1973 is concerned. If you go to his skeleton, at paragraph 39, which is at page 20, so what he says is 3 lines down. It seems to be common ground that the conditions on which proceedings before the DIFC courts could be adjourned to allow reference to be made to the USC have been considered by the court in X and Y. Insofar as Meydan claims that the arbitration law is in conflict with the judicial relations law, the decision confirms that the USC has jurisdiction to consider the constitutionality of DIFC laws. Of course, he says it doesn't apply. He accepts that the court has the power to do so if it considers that the conditions are met. So he says that if the conflict is with the Civil Procedures Code, you need two conflicting judgments before you can refer, and you'll see that from paragraph 40 of the skeleton. So he says that you have to have two conflicting judgments. Now we say that's wrong. You don't need two conflicting judgments. What you see from Union Supreme Court law is that you need a plea of unconstitutionality, which is accepted by the court. Provided you can show that.
Yeah, if I understand you clearly, you want to say the IFC court is UAE court and constitution law is applied, and Article 151 plus Article 151 of UAE Constitution and Article 58 of the Supreme Union Court give me an authority or give me a way to send to stay the proceeding and send it to Union Supreme Court to determine the constitutionality of the DIFC law. This is the way you want to put it.
Essentially, yes. Yes. I think that's common ground, actually, but the question is whether the test is satisfied. So what I need to show is that the complaint is a serious one, that it's serious. If you don't think it's a serious complaint, then that would be a different matter. So you saw from X and Y that what Judge Ali said in X and Y was that you should consider it as the same level as would be pleaded before the USC. But obviously that doesn't mean that you today, this court, has to make a finding that the law is unconstitutional. You must exclude it. If you think that our case is frivolous, for example, which I would suggest is not the case at all, but if you were to find that, then you could see that you wouldn't permit a reference to USC because you think the case is frivolous. But where you have a serious issue like this, we say it's seriously arguable and that the court should refer if you're against us on construction. Because otherwise, what would happen is that this court is taking for itself a power to decide the issues themselves, whereas that's the USC's role. So provided you're with us, there's a conflict and the difficulties that we've dealt with, and as the Constitution is engaged, public order is engaged, we do say that this is an appropriate case for a reference to the USC. It's a very important case, raises very important issues. And we say it is more than seriously arguable, but if the test is serious arguability, we more than meet it, that there is a conflict between federal legislation on the one hand and Law 11 of 1973, the CPC, and the requirements of publication which flow from the Constitution in Arabic. All of those issues come together. They're very fundamental, they're very important, and they are essentially a matter for the USC, not for this court. Now, I should emphasise how that sits with our primary case, which is that we only get into constitutionality if we're wrong on construction. And our arguments on constitutionality are secondary to our arguments on the construction of Article 42. Our primary case is that you should, applying well-known, well-established principles of construction, you should interpret Article 42 to exclude domestic awards. But if you don't do that, if you feel compelled, as my learned friend says that you should be compelled to conclude that the only conclusion you could come to is his construction of Article 42, then you have a whole range of problems which I've already described, including a conflict of legislation. There are other problems, but whatever those other problems are, you are certainly, for the purposes of constitutionality, left with conflicts of legislation, and those are matters which require, in my submission, examination by the USC, and we would ask you to make a reference on that basis. So that was all I was going to say about constitutionality and construction. unless I'm told that I'm to make any other. So that was all I was going to say. And then I was going to pass over to Mr. Reed now to deal with his submissions, which is whether, if the court has jurisdiction, it should exercise it. Unless you had any questions on that first aspect of the case.
Okay. Just I want to correct one information which I refer to the law number 1, federal law number 1, 1971. It's in respect or in regard to official gazette. It was, I mentioned 1973. It is law number 1, 1971. Sorry to.
Thank you. No, that's very helpful. That's very helpful, Your Honour.
By way of route, I could ask you to take up bundle A, which is the slim bundle.
Okay, let me organize the additional document.
No, it's not addition. It just says hearing bundle 7th and 8th of February 2016. Yes, it should just say hearing bundle on the spine.
Volume?
Volume A, file 1 of 1, if that helps.
Just contain level steel order?
My Lord, yes, that's at the beginning, but at the end of that bundle, behind tab 7, Your Lordship has the draft order for the application which has been made by Meydan.
Yes.
And just to explain how the bits fit together, which my learned friend was explaining just a moment ago, one is a declaration the court has no jurisdiction, and then the learned friend explained and that's a matter of instruction. And then the alternative order is that in 4, i.e. the constitutionality issue, the issue being referred to the Union Supreme Court. Where I come in is essentially paragraph 2 of the draft order, which is an alternative to the declaration of no jurisdiction, and that's to say the court would declare that it should not exercise any jurisdiction. Now, in terms of the discretion to enforce an arbitral award, Your Lordship may be aware of a certain amount of judicial controversy as to whether there is a discretion, to what extent there is a discretion. That was discussed at some length in the case of Banyan Tree, which Your Lordship has in bundle 1 of the authorities bundles that my learned friend, Mr. Flynn, was referring to. If I could take Your Lordship to, it's behind that case, behind tab 22 in bundle 1. This is the judgment of Justice Steele in the Court of Appeal. If I could take Your Lordship to paragraph 33. The absence of assets in the jurisdiction may be a relevant consideration to the exercise of discretion to grant execution. But even then, a judgment creditor is entitled to levy execution against assets which come into the jurisdiction after the judgment is entered and which did not even exist at that time. So he's considering there what has been referred to, by way of shorthand, as a residual discretion. And that issue is picked up again at paragraph 43 in the same judgment. So a couple of pages on, it is right to say that there is no evidence laid down as assets within the DFC or otherwise within the jurisdiction of the DFC courts. There's no basis for asserting that the application for enforcement within the DFC has no independent purpose. So what he's alluding to there is the basis of the residual discretion is an issue of whether there's any independent purpose in enforcing the award. Now I think I'm bound to say that there have been judicial decisions subsequently which have thrown doubt on the issue as to whether there is a residual discretion. And in explaining what the residual discretion is, it may be worth looking briefly at the arbitration law, which your Lordship was being shown behind tab 11 of Buffer 1. And if I could take your Lordship back to Article 42 of the arbitration law. Article 42, sub-article 4, awards issued by the DFC court may be enforced in the DFC. So the maybe there lent itself to an argument that there was a residual discretion. And that, as I should say, is controversial. Insofar as there have been decisions subsequently that there should be no residual discretion under 42.4, we say those decisions are wrong. And we maintain that point. We keep it open for any appeal. But be that as it may, in dealing with 42.4, if one looks at 44.1a over page, that's to say the grounds for refusing recognition or enforcement. 44.1, recognition or enforcement of an arbitral award may be refused by the DFC court only. So if those 44.1a circumstances, or any of them, applies, then the court essentially has a discretion to refuse to enforce, or in effect, a discretion to enforce. Now, the jurisdiction in this case is under 5A1E, and your Lordship has the Judicial Authorities Law behind, the Dubai Judicial Authorities Law behind tab 9. 5A is at page 3 of that section of statute behind tab 9. So the Court of First Instance shall have exclusive jurisdiction to hear and determine, and then over page 4, little e, any claim or action of which the courts have jurisdiction in accordance with DFC laws and DFC regulations. So to the extent that there is a power, discretionary power under 44.1 to enforce an award, the jurisdiction under 5A1E maps the power. So to the extent that there's a discretionary power of the court, in effect, to enforce an award, we say it's a discretionary jurisdiction in this court. This court, even if it has jurisdiction, does not have to exercise it. And we say that that is consistent with the law as it exists in England, which is where, and my own friend draws the distinction, the procedural differences. But where in England you're seeking permission to serve the process out of the jurisdiction, the court has a discretion in that matter. And in exercising that discretion, the court looks at two things. First of all, whether there's a jurisdictional gateway. So does the case come within one of the jurisdictional heads? And those are clearly recognised in 5A, A to E. But also, is there a good arguable case on the merits? And certainly in English law and most of the common law jurisdictions, those are two entirely separate, discrete tests. And we say they are too under DFC law. Now, in terms briefly, just in terms of why the court should not exercise its discretion, just so that your Lordship sees where we're coming from. First of all, as my learned friend rightly said, we have concerns where issues of enforcement are at the same time being heard before the Dubai courts and the DIFC courts. My learned friend has worked that point in terms of the risk of inconsistent judgments, the risk of race to judgments, the duplication of costs, etc. I don't want to remake all those points, but those points exist and are argued too in favour of, or in arguing the court shouldn't exercise jurisdiction. And the second reason is, we say, because the claim lacks substance. There are very significant defects in the award. And as I've said, there are two distinct tests. The claim is required to have substance in order to engage the jurisdiction. So if it comes within a gateway, it's then further required to have substance. And the test we say for that is a good arguable case. And I'll explain what that generally means. Now, the lead case on this, if you like, is behind tab 1, bundle 1, tab 28. That's the case of Hart and Dalek. You could look at that now. And if we could start at page 3 of that judgment, the top of page 3, paragraph 5. I attach this judgment a copy of the particulars of claim. I should say this is Justice Sir John Chadwick. We've seen at once this document is totally unsatisfactory and insufficient as a DFC court pleading. It fails to do more than make bold and unparticularised allegations against the defendants generally. It gives no factual explanation or particulars of what conduct by each separate defendant is relied upon. Also seeks to introduce into the claims companies in the DANAC group which are not identified in the claim form. The first defendant is a DIFC DANAC group company. It was not and is not alleged to have been a party to any of the contracts. And the particular claim contained not a single allegation of conduct by it, as distinct from the other defendants, relating to any of the contracts in question. According to the evidence, it had no dealings with the claimant relating to these or any other contracts. So that's his sort of introduction to the issue, if you like. And then if we could take your lordship to paragraph 59 of the same judgment. The salient facts are as follows. The first defendant, although incorporated in the DFC, was not a party to any of the contracts. And then moving swiftly on to little e, no allegation or breach of contract or duty is made specifically against the first defendant. And F, against this background, is argued on behalf of the claimants and there's jurisdiction under Article 5A1A on the grounds that both the claimant and the first defendant are centre establishments. And then over page little g, dealing with the status of the first defendant, that's to say the DIFC DANAC entity. Secondly, by contrast, the first defendant would appear to be one of the centre's establishments. It's located in the DIFC, and on the evidence of Mr. Doolan is a financial investment company whose activities primarily involve arranging credit and advising on financial products. It is said that it's never had any involvement in the property sales or developments, whereas the particulars of claim refer to breaches of contract and duty by the defendants or by DANAC. They contain not a single allegation of fact or law specifically directed to the first defendant. The next paragraph 60. The total absence of any specific allegation against the first defendant is, in my judgment, important. If a claimant fails to make any coherent allegation against a centre establishment, although the party may be joined as a defendant, he is not a party against whom the claimant raises a case which can found a dispute. All he has done is put a name on the DFC court's claim form and nothing else. In these circumstances, no dispute involving that defendant has been properly identified. And the DFC courts do not have jurisdiction under Article 5A1 to do more than strike out the claim against that party. Where there's no formulated claim, there is nothing which engages the court's jurisdiction. Well, my learned friend emphasises the word claim and says, well, it's an issue about whether there's a claim. But actually, if one looks in the paragraph, the question or the issue is whether the claimant has raised a case or has founded, or there has been found a dispute. In other words, the claim has to have sufficient substance or merit that it can be said, properly said, to raise a claim, or raise a case, or to found a dispute. And indeed, the analysis there is in terms of engaging the court's jurisdiction. So there has to be a claim of sufficient merit and substance to engage the jurisdiction. It's not enough simply to state a claim or to make a claim against a particular defendant, an anchor defendant, if you like. There actually has to be some substance to that claim. The following case, which develops this line of authority, is the Farafi and Bank Saracen case, which is the following tab 29, the same bundle. My learned friend has some advantage from me in that he was in this case and was arguing for the defendant against jurisdiction. But if I could pick up paragraph 72 to 74, actually, if I could start at paragraph 69. Inasmuch as Ms. Naz and Mr. Nair operated from Saracen Dubai offices in the DIFC, there were relevant incidents in the DIFC which formed one of the components of the claims for misrepresentation and negligence against Saracen Switzerland. We now refer to the submission that those claims have not been shown to have sufficient substance for this court to exercise jurisdiction. So, no matter what is said in the judgment, the submission that appears to have been made on behalf of the defendant, in this case the second defendant, Saracen Switzerland, is that the claim didn't have sufficient substance for the court to exercise jurisdiction. So the same analysis in terms of is there sufficient substance in order to engage the jurisdiction of the court. So going on to paragraph 72, without deciding whether Saracen Dubai were agents in the strict sense of being clothed with authority from Saracen Switzerland to create privity of contract between the latter and third parties, we find there is at least a good arguable case, and ask your Lordship to underline those words, because that is the test that is being laid down by the Court of Appeal in Saracen, that they were employed by Saracen Switzerland to market its investment products. There is no evidence of the internal group terms on which Saracen Dubai acted in that capacity. However, we infer from the conduct of Saracen Dubai personnel involved and their apparent system for instant contact with Saracen Switzerland, they were employed as a nominally independent but in-house marketing organisation. In that capacity, as an independent contractor, their conduct in relation to the marketing of these products could not give rise to the vicarious liability of Saracen Switzerland in the strict sense. However, if their defective conduct had been specifically authorised by Saracen Switzerland to the effect of misrepresentation and non-disclosure risk was specifically authorised, Saracen Switzerland could incur liability as a principal tortfeasor whose tortious conduct had been delegated to Saracen Dubai. So what is said against us is that, well, the merits test is really a test of whether the jurisdictional gateway exists at all, because that requires Saracen Switzerland to have been involved in an incident in the DIFC. So there is, on the facts of this case, a coincidence between the substance and whether the jurisdictional gateway was engaged. Having said that, if one looks at paragraph 74, the test is again put in terms of two separate tests, substance and engagement of the jurisdiction. That would be the position in English law. There is, however, no evidence as to the position in Swiss law, which could apply if the law of jurisdiction laws were binding. Accordingly, on that hypothesis, it's permissible for this court to presume for the present purposes that Swiss law is the same as DFC and English law, and on that basis to conclude that the claim against Saracen Switzerland is shown to have sufficient substance for this court to exercise jurisdiction, provided that one of the jurisdictional gateways is engaged. So again, a bipartite analysis first of all of the substance. If the claim has sufficient substance, then you look to see whether the jurisdictional gateway has been engaged. Now, just in terms of what the courts mean when they start talking about a good arguable case, if I could take you briefly, my Lord, to bundle 2 in the authorities, behind tab 38. We have the decision of the English Court of Appeal in Canada Trust and Stolzenberg. And if I could pick up the holding in the headnote, held dismissing the appeal that the English Court had jurisdiction under Article 61 of the Lugano Convention or the Rules of Supreme Court Order 11, the plaintiffs had merely to establish a good arguable case the first defendant was domiciled in England at all material times, and the concept of a good arguable case required a degree of flexibility that did not require proof as high as a civil standard to balance the probabilities, but higher than where there was a serious issue to be tried. And the judge, having applied the correct test, had been entitled to rule that the first defendant was domiciled in England at the material time. Now, the explanation is at page 9, bottom right-hand pagination. Sorry, tab 38. And then in terms of the internal pagination of the case report at page 555 in the top right-hand corner. And your Lordship has it there in the red box between letters F and G. The court in such cases must be concerned not even to appear to express some conclusive views of the merits, e.g. as to whether the contract existed or not. It's also right to remember that the good arguable case test, although obviously applicable to the ex parte stage, becomes the most significant at the inter partes stage, where two arguments are being weighed in the interlocutory context, which I've stressed, must not become a trial. Good arguable case, which is the test that was applied by the Court of Appeal in DFC in Kharafi, good arguable case reflects in that context, i.e. the inter partes context, that one side has a much better argument on the material available. It's the concept which the phrase reflects on which it is important to concentrate, i.e. of the court being satisfied, or as satisfied as it can be, having regard to the limitations which an interlocutory process imposes, that factors exist which allow the court to take jurisdiction. And that, we say, is what the Court of Appeal in Kharafi was meaning. That, we say, is the test. That is what is meant by good arguable case. Relying on materials available. On the materials available, does one side have a much better argument? And we say the issue on which, the issue of substance on which your Lordship has to consider is that of the enforceability by reference to the 44.1a factors or criteria, the enforceability of the award.
There's no asset here.
There's no, it's not, no, we're not going under we are saying that there is a residual discretion under 42.4. Because so the example of the consideration of whether there are assets in the GIFC, that is a proportionate exercise of the residual discretion under 42.4. We are maintaining that your Lordship has that residual discretion, but we're also saying that there is no debate